Great. So why don't we kick off? So today we're going to talk about changing wills. The first of all, the effects of change in circumstances on wills, alterations, codicils, revocation, and then some advice to our clients about these topics. So let's first deal with sort of the very basic idea that generally a change in circumstances, with some notable exceptions, doesn't affect a will. And you can see here, we have the current and the pending, and there are some dramatic changes here. Ian, do you want to just talk about the current and where we're going?
Sure. So just hot off the press is really on the question of marriage, and one of the things I always just wanted to open with, but you didn't ask me to, so I will now, is the changing in wills. On the litigation side, it's almost depressing sometimes what you see, because clients think it's like changing a check, and too much cost and effort goes into this. And so one of the things that I like to make sure I emphasize with my clients once the will is done is just please be careful with the document itself, because we're going to talk about what the impact of marking up and so on has on it. But it is such a profound mess when someone doodles on a will. And I can tell you, it's unfortunately 5% of my practice. And it's not everyone, but it's worthy of just helping remind our clients. But just in terms of the changes, so red hot off the press is April 19th, 2021, Bill 245. It was called the Accelerating Access to Justice Act. It received royal assent. And why that's important is that the government had introduced, with regard to change in circumstances regarding marriage, the government introduced Bill 245 in February of 2021. So relatively speaking, and lightning fast effort on the government's part, some changes came into place. In particular, the changes relating to marriage and marriage revoking a will. I just want to say that the change, though, with respect to marriage and marriage not revoking a will that was in the legislation has not come into effect. And its pending effect is as a consequence of the legislation. It says it will come into force in effect to be proclaimed by the Lieutenant Governor no earlier than January 1, 2022. So we are in the middle of a sort of pause on that profound change in the law, and it is from my perspective anyway, we're going to see a regulation that's going to pass it probably before the deadline, of course. But we are when you say pending, it is much more pending than it was even a week ago.
Yeah, exactly. And so, as we stand today, right, the two things that change a will automatically are marriage and divorce. And shortly, probably beginning of next year, marriage will no longer revoke a will automatically. A divorce will still have ramifications, and now separation will have ramifications. Those are those automatic change in circumstances, and they're very limited. It's only with respect to your marital status in effect. These are kinds of changes that don't have any effect on wills. And many clients don't recognize this. And it's important, I think, for us to emphasize this with our clients. Look, changing residency or citizenship, changing your assets, acquiring new assets or selling assets, it doesn't automatically change your will. Having children or grandchildren doesn't change your will. And typically death of a beneficiary isn't going to change your will. So things like that have to be addressed either in the drafting of the will specifically, or they just have to be, the client has to be aware that, look, you should come back if any of these things happen and change your will.
Yeah, one of the things that the United States government has done is made it clear that you can never change your citizenship. The U.S. government takes it as you are born in the U.S., you are always born in the U.S., and they will treat you as a U.S. citizen. So that can have dramatic impact on your planning. So that's always one of the easy ones to identify and highlight. And too often I get into cases where someone has said that well, yeah, my aunt was born in the US, but no one ever talked about it. And that she lived in Manitoba all her life and then came to Ontario, and everyone had forgotten that she lived in the US. And the citizenship in that regard can affect the planning.
So I just wanted to briefly address that last issue about the death of a beneficiary, just a warning. Um, and so this is one of those where a will is automatically changed in certain circumstances, or the distribution is automatically changed. And this is the anti-lapse provisions, and we sometimes refer to them, just so you know, they're under Section 31. So it's basically a sibling or a child or grandchild. And if you make a gift to them in your will, with no survivorship condition, so you don't include if he survives me or language like that, and that beneficiary predeceases the testator, there is this automatic change to the distribution. And that means that, for example, if I leave a gift to my brother and I say $50,000 to my brother, period, okay, with no survivorship clause, $50,000 to my brother, period, he predeceases me, and that $50,000 doesn't lapse. Instead, it goes to his intestate heirs, so his spouse and his children. So that's important to remember. Now, most of the time, that's one of the reasons we use this language. We use this language of survivorship in wills is to avoid the anti-lapse provision, because we do want that gift to only go to that person if they're alive. So I just wanted, because sometimes we miss that one as a change in circumstance exception. So Ian, I know it takes up a lot of your practice, which is when we make changes to wills. Do you want to maybe, give an example or?
Sure.
One
of the famous cases on this, and one that's been around a long time, Riva got into this debate, and certainly that was a question of where the location of the signature was, and the court had to adjudicate on the fact that the signature wasn't at the bottom of the page. And in this case, the alterations is a little different. And that is, of course, when you have what I said earlier, this is where people treat a will like a check, and they think that they can make the change and initial it. And often what happens is, of course, it's not properly done in accordance with the Succession Law Reform Act. And that's what this slide is getting at. What are the requirements to make the alterations in that regard?
Yeah, and so many. I mean, who hasn't seen some client who came in with the original will with handwritten notes on it, and initials, and they say, oh well, so I made the changes, but of course those are not valid changes. So once the will is signed and executed, okay, that's what we're talking about now. We're talking about changes after the will has been properly and duly executed. Now, at that point, any alteration on the face of the will requires the same kind of formalities as the formal will itself did. It requires the alterations to be signed by the testator and witnessed by the testator. And so really a crucial matter. If they're just handwritten with initials, those are not valid. You can ignore those, and courts will ignore those when they create or when they issue probate with respect to those wills.
And of course, the issuance of probate is always balled up on that, because the registrar sometimes doesn't know what to do with the changes, and sometimes you have to get court assistance. So that's why the sanctity of the document is so important. I always say that the original document matters, and the sanctity of the document itself and its form matters.
Right. And we'll get to sort of what we should be doing with our clients about these issues. But there's no easy way to change a will without doing it in the proper form, with witnesses and signed, etc. Then there's obliteration, one of my favorites, because the cases are so interesting on this. And this is where instead of simply crossing something out and changing it and initialing it, which wouldn't be valid, there is this possibility to obliterate, so completely get rid of a provision of the will or words in a will, in which case, of course, they're not typically signed and witnessed, that obliteration. And so there is this ability to exclude those words that have been obliterated, even without it being signed. Ian, do you want to talk about this? This area about obliteration and no longer apparent?
Well, it almost comes down as simply as this: is if you can put it up to the light and you can read it without, as you say, artificial means, it's not properly obliterated. And there's some great old British cases that talk about how they're going to delineate whether it is obliterated or not. But the court will not bend over backwards to read through the obliteration, and will not look to, as you've identified, artificial means.
So sometimes you see that where something's been scratched out with marker or that kind of thing. And if you cannot, like you say, hold it up to the light and read what it is, then it is obliterated and you disregard those words. So there's an alteration that actually exists that is valid, even though it hasn't been signed. You sometimes hear the cases and see it where someone is literally cut out the sentence physically with a pair of scissors. There are cases about that. So that's an example of an alteration that doesn't need it to be signed, but it's a very rare and kind of, unusual.
You have to be, it's a dangerous game because even a Sharpie doesn't always obliterate.
Correct. Yeah. So let's get to another way of changing wills. And we'll talk about the best way to do it in a second, but let's just talk about codicils. You have anything, clients throw this term around, codicils, all the time. What do you have to say about that? Yeah.
Well, I just make this initial observation that from a practice standpoint, it's a tool that is used, was much more used, obviously, in days when it was without the ability of computers and printers that will pull together the materials so quickly. So I get that, and that was the practice, but it turns into a bit of a lazy practice, and we're going to talk about that in a minute. In my view, codicils, even them in and of themselves, can be a dangerous game, and what errors can occur on the cross-referencing. And so my general preference from a practice standpoint is to stay away from codicils unless I have.
And there's no special wording. So a codicil just is an amendment to the will, in essence. It, first of all, requires all of the same formalities that a will requires. So it still has to be a valid will for it to be a codicil, in essence. And the definition of will includes a codicil, just so you know, in the Succession Law Reform Act. But there's no special wording that's absolutely required. But the general rule is that if you make a codicil, and typically you're just changing a small part of the will, what that has the effect of is republishing the whole will with the change that you've made in the codicil. And so now the date of the will is actually the date of the codicil. And so that can have effect on interpretation issues and other things, but that's the effect of a codicil. And I've put in here that it generally republishes the will. That is a question really of intention. And that is why most wills do say, and I confirm the terms of my will and republish it, because it is a question of intention.
Yeah, and the whole question of the use of codicils, as you mentioned, I mean, the difficulty is, of course, that capacity issues get revisited then, and sometimes, too often, in my experience, the creation of the codicil is done, and the general will, there's no evidence of it being anywhere near the testator, or with the lawyer, or even cross-reference physically, and that brings about a whole bunch of knowledge and approval and capacity questions. That if I'm going to do the codicil, I always like to have the original will there with me, because otherwise, you've done is you've opened yourself up to exposure.
Let's just talk about some problems with codicils. I'm going to name off a couple, and I'm sure you'll have a few more. The first is that there's some misreference to the paragraph. So you say, I'm changing paragraph 2, but in effect, it's not paragraph 2, it's paragraph 3, or you have the date of the will wrong, or there's another codicil that's already there. Those are some sort of typographical problems. Ian, any other ones that you?
Yeah, well, I mean, look, I think again, sometimes obviously due execution is essential to any testamentary document of this nature, but it's the cross-referencing that gets balled up, and as you say, it may not be as easy to identify as the numbering, but rather it may identify the clause as the wrong clause, and you may be descriptively changing gifts. And so that's why, again, I come back to my preferred practice continues to be stay away from codicils, just because, we all worry about section sub A, sub B, sub 1.1, but those are the tip of the iceberg of the problems that get created when you create a new document like this.
The benefit of a codicil, however, and Ian and I have both used this before, is where the will itself is improperly executed, or there's unattested alterations, and now you do a codicil. Well, what that does is actually it validates the will, because now the codicil is validly executed. It means the will is now validly executed, as well as the alterations that were included in that. So that is one benefit of codicils. But I agree. I mean, typically we try to stay away from them. Clients love to, I'll just do a codicil. I'll just do a codicil. Well, they're a pain when you go to probate them, and there's missing ones. You refer to the fourth one, but you can't find the third one. Anyway, I stay away from it as well. So let's talk about revocation. We have a bit of a problem with our law, I think, in some ways. And it has to deal with revocation. So I'm just going to take the first one, and then you can take the second one. You can have more fun with that. So how do we revoke a will? Well, it can be revoked by a subsequent document, which is the typical way, right? In a new will, it typically says, I revoke all prior wills. Well, that's revoking the prior wills. There's even that presumption, even if you didn't have a revocation clause, if this subsequent will dealt with all of the assets, it in effect implicitly revokes the prior will. You can also do a revocation without actually doing a new will. You can actually just do a revocation, a document that simply says, I revoke all prior wills. And then you would die intestate, assuming that document was generated or executed in accordance with the rules about wills. Now let's talk about what can be seen as a problem with our current law, and that's the destruction revocation.
Sure. Well, I'll just talk a little bit about this from the litigation standpoint. You see this often where a solicitor will be in the room and they will tear up the will, and they will do the act of burning, tearing, or otherwise destroying in front of the client and say, that one's done and it's over. And then we get into a will challenge and we find out that no, indeed, the will that the lawyer just did for the client is invalid. And then without getting too deep into the academics of it, then we get into the concept of dependent relative revocation, and we start going one will at a time. So the actual act of destruction was ineffective if the prior will was destroyed, is invalid. And so and the other practical aspect of revocation problems that come about is so burning and tearing doesn't always work. And you're also looking at, most of the time we can find a copy of that will, even if it is burned, destroyed, or torn. And if I can get there for the purposes of the will challenge, then I can get there through a soft copy in a computer. So we have the actual, it's like, so we can't get rid of it in a sense, physically, from that standpoint. And that's very relevant when you get into will challenge.
And it requires two things. And sometimes, people always ask, well, what happens if my house burns down? Or what happens et cetera. I mean, the destruction of the original document requires both the act of destruction and the intention to revoke. If you accidentally destroy your will without the intention to revoke it, it's technically not revoked, in which case you could prove a copy. So it requires both the mental and physical acts. And the important thing as well is to, and for clients maybe don't recognize this, but that doesn't mean that the will before that is revived. So the will before that was revoked when you did this will. It can't be revived now by destroying this will. And that's something just to keep in mind for clients. I mean, if you ever, I'm sure clients don't necessarily even know that. So there's a bunch of things that clients would not know and are actually very surprised about. And one of them is this idea, again, that destruction of the original document. The reason I say this is a problem is because it leads to the reality that if you can destroy or revoke a will by destruction, which, by the way, doesn't apply to any other document. It doesn't apply to powers of attorney. It doesn't apply to life insurance declarations. It doesn't apply to contracts or any other thing. It only applies to wills. Well, so what? Like, who cares? Well, this is the reason it's a problem. It's because if we can't find the original, it's presumed to be revoked under certain circumstances. And because you can revoke a will by destruction, we have to deal with what happens if you can't find the original. If you couldn't revoke a will by destruction, we wouldn't really care about the original, and we wouldn't have all these problems with finding the original. But we have this rule, and it's a rule from historically from the 17th, 18th, and 19th centuries. So
when originals were much more important.
Right, where they weren't making copies. That's the reality. You didn't make a copy.
And they were trying to prevent fraud.
Right. So it made sense then. I don't think doesn't necessarily make sense now, but we have it. And so we have this problem. Ian, do you want to just address the idea of presumption of revocation when we can't find the original?
So it's presumed, well, to prove a lost will, a will that's been been lost itself, is that the presumption is that it has to have been last, and it is revoked if it was last in the hands of the testator. And so in this case here, you've got the find that there is no original will, then it has to have been last in the hands of the testator. And of course, as solicitors, we get into this danger zone because we may well have had the will last in the sense that we've been asked to hold the original will. And so the presumptions can weigh heavy on us, and it can lead to exposure to us from a negligence standpoint. Because if someone says to me, here's my original will, you hold on to it and put it in your safe, well, and you lose it, then you have to, there's a presumption that it was last, it is revoked if it was last in the hands of the testator. Well, in that case, as a solicitor, it was last in your hands. But if you can't prove that it was last in your hands, and there's some gray area there, then you're into a lost will application, and all you've done is put yourself in the middle and expose yourself to the cost of that lost will application.
Yeah, and so that's important to remember, that this presumption only applies because only the testator, or by his or her direction, can a will be revoked by destruction. So if that's why we have this presumption. Now, there are so many wills that are just lost, to be honest with you, and they probably exist and they're probably valid, but nobody can find them. And if you can't find them, then you're into a situation where it's presumed to be revoked. And that means that if you prove that it was there and now it can't find the original, then we've got an intestacy. And there are rules about how you can over the counter get a lost will proven. You need the consent of the next of kin and the beneficiaries to that will, and then the court will prove a copy. But it is a big problem, and it's a huge problem because we allow revocation by destruction. That's really the reason it's a problem. So in our concluding 5 minutes, maybe we can, and we have a couple of questions, but let's go to the idea of, what should we be doing from a negligence point of view for our clients. So let's talk about some of these. One is the importance of the original. I think we've explained that. I find it's always surprising to my clients when they say, but you'll have a copy. And I say to them, it doesn't matter that I have a copy. It doesn't matter if we find 50 copies in your possession. It's the original that matters because of this rule. And clients are, I'm sure I'm not getting through to many of them on that, but really important. Ian, any other points?
Well, I think, yeah, just, and on that point, the way I get to clients is that, it's not a perfect system, but it's the best we got. And really, at the end of the day, they have to understand that that is the rule. And so we originals, whether you and I can work on our legislation and legislators and try to figure this out someday, but until that changes, the originals still matter.
So if any of you are eState users, you'll know that our reporting letter includes some of these warnings, and I can include this in my report to the client. I put it in writing to them. Like, this is again an issue to avoid somebody coming back and saying, well, you didn't tell them how important that was. So I say, look, if you can't find the original, it's presumed you didn't have a will. And so that's the first thing. And so clients often ask, well, what happens if I lose my will? So I always just say this. If you just misplace or lose your will, send me or send someone an email that says, look, I've lost it, but I didn't mean to revoke it. Because that will get us over the presumption. And I did this myself once at the airport when I couldn't remember where the original was. I sent myself an email that says, I don't know where the original was, but it's the same one that was on my computer and I didn't revoke it. So that's how it came to me that this might be a way for clients, until we sign a new one, to get over that presumption.
Yeah, you're not going to the airport much these days.
Sorry?
You're not going to the airport much these days.
No. And then just a suggestion that you let people know where the original is so that they can find it. Because if they can't find it, it's no use. So those are a couple of points there. The other thing that I also put in my reporting letter is this idea is, if you want to change your will, don't make handwritten notes on it, because they will either not be binding or lead to confusion, and get an estates lawyer to help you. That's sort of what, and if you use our reporting letter through eState, it'll do that. So those are the sort of things that I want to, make sure that I'm covered off on if I'm giving the original back to the client. Any other comments before we take we have a couple of questions, and Ian, any concluding remarks before we take one?
No, let's take that. No, they'll finish the questions and then we'll wrap up. We're 1 minute out.
Yeah. So what do you do with your clients who have signed a new will? Do you tell them to destroy the previous will when they're revoked by a new will?
Well, do I? You want me to answer that one? Yes.
Okay, I'll answer it.
Sorry, you go ahead. You answer.
Okay. So again, revocation, it's revoked by the new will. The reason I'd say to them to destroy the old one is I don't want somebody finding that old one and thinking it's the latest one and then trying to probate it. So I'm fine with the client destroying it. I'm also fine with keeping it in my file, because either they had the capacity to revoke it and the will is valid and it's revoked it, or they can revoke it by destruction. I'm not sure it adds much to it. But that's why I keep the old one just in the file. But
absolutely, and the digital copies are kept anyway, almost anyway, and you can always find the metadata. So as I said at the start, you can't really get rid of it.
Yeah. And somebody just asked about a precedent reporting letter. So I think, and this person is an eState user. So if you're an eState user, check your documents, because one of the documents you can generate automatically is the reporting letter. That's actually not just a precedent. It's customized to that client's particular circumstances with the warnings that are applicable to that client. So just to do that. And And is there a proper way of destroying a prior will? Do you have any comments on that? That's our last question.
Well, again, it's the old school. Ripping it is the advantage of in front of the client, is the advantage of having that dramatic moment. But I think we've sort of canvassed that. I apologize. I've got to jump, and I know we're at the time.
Thank you all.
So thanks, Bertie.
And thanks, Ian. And thank you all. And we have some good news coming we have a surprise special guest coming in May, which we'll give you more information on. But thanks again for joining us, and we'll see you again next Thursday. Take care, everyone.